SwayamPrabha. Digital India. Educated India.
Good morning, students. My name is Shalini Sharma. I am child right working professional, having experience of 5.5 years as chairperson Child Welfare Committee and 1.5 year in my present role as member Juvenile Justice Board. Today, I am here to take up your lecture on Juvenile Justice, Care and Protection of the Children Act. And our module for the day is Juvenile Justice Board. Before we start with our lecture, let's have a brief introduction of this Act. The Juvenile Justice Act 2015 is a law in India that deals with the care and protection of children. It was enacted in 2015 and replaced the previous Juvenile Justice Act 2000. The Act defines a child as a person who is below the age of 18 years. This Act defines child in two different categories: child in need of care and protection, children in conflict with the law, and children in institutional care. The Juvenile Justice Care and Protection of Children Act 2015 is an act to strengthen and amend the law relating to children who are alleged to be in conflict with the law and children who are in need of care and protection by meeting their basic needs through adequate care, protection, development, treatment, along with the social reintegration by adopting and implementing a child-friendly approach in the arbitration and disposal of matters and cases in the finest interest of children and for the rehabilitation of children. Students, in lecture number 1, we have studied the evolution of Juvenile Justice Act. In lecture number 2, we studied about Child Welfare Committee, a statutory body under this Act. We also learnt about the powers and the functions of the Child Welfare Committee in our previous chapter, and in today's lecture, we will study about another important statutory body established under Juvenile Justice Act. We will also learn about its functions, its roles and responsibilities. So, Juvenile Justice Board. A separate justice system is provided for dealing with juveniles, children in conflict with the law in India, which is based on the principle of doli in capex. Child cannot procure criminal intention. The JJ Board has the exclusive power to deal with the proceedings under this Act relating to children in conflict with the law. The Board has the responsibility to ensure that the child rights are protected throughout the process of apprehending the child, inquiry, aftercare and till his rehabilitation back into the society. Juvenile Justice Board is constituted under Section 4 of the Juvenile Justice, Care and Protection of Children Act 2015 and is covered under Chapter 3 of the same Act. Now, let's have a quick recap of some definitions which we learnt in our previous lectures. Who is a child? The Act defines a child as a person who has not completed 18 years of age. The Act classifies the term child in two categories, namely child in conflict with the law and child in care of protection. The mandate of the Juvenile Justice Board is to look into the cases of child in conflict with the law. Now let's understand who is a child in conflict with the law. As defined in section 2, subclause 13, is a child who is alleged or found to have committed an offence and has not completed 18 years of age on the date of commission of such offence. The inquiry processes for children in conflict with the law will depend on the basis of offence allegedly committed by the child is mandated by the Juvenile Justice Care and Protection of Children Act. Now let's see what kind of offences are committed by a child. First, petty offence, which is defined under section 2 subclause 45. It includes the offences for which the maximum punishment under the Indian Penal Code or any other law for the time being in force is imprisonment up to 3 years. Example, assault causing simple hurt, etc. Serious offences is defined in section 2 subclause 54. It includes the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is more than 3 years and not exceeding 7 years. Example, stealing or selling drugs. Heinous offences. Section 2 subclause 33 defines the term heinous offences, which includes the offences for which the minimum punishment under the Indian Penal Code or any other law for the time being in force is imprisonment for 7 years or more. Example, murder, rape. Now let's understand the composition of the Juvenile Justice Board. A board shall consist of a metropolitan magistrate or a judicial magistrate of first class, not being a chief metropolitan magistrate or a chief judicial magistrate. Hereinafter, the principal magistrate will be as same as metropolitan magistrate. The point to be considered in the composition is that for the purposes of Juvenile Justice Board, a metropolitan magistrate is made mandatorily because the CJM or the chief metropolitan magistrate may be busy with the other works. The intent of the act is for the speedy disposal of the cases of the children. So, principal magistrate is made mandatory to be part of the Juvenile Justice Board. And in addition to principal magistrate, there should be 2 other members. Should not be less than 35 years of age and 1 member should be a woman. Experience required. Active involvement for 7 years in health, education or welfare activities pertaining to children, or a practicing professional with a degree in child psychology, psychiatry, sociology or law. And for the principal magistrate, experience of 3 years is mandatory. Now, the disqualifications for being appointed as a member in the Juvenile Justice Board. As per section 4, subclause 4, no person shall be eligible for selection if he has any past record of violating human rights or child rights, has been convicted of an offence involving moral turpitude, and such conviction has not been reversed or has not been granted full pardon in respect of such offence, has been removed or dismissed from service of the central government or a state government or an undertaking or corporation owned or controlled by the central government or a state government. In other words, any person with tinted past cannot be appointed as a member in the Juvenile Justice Board. Has ever indulged in child abuse or employment of child labour or any other violation of human rights or immoral act. As I said earlier, no person with a shady past or a shady history is selected for the Juvenile Justice Board. The state government has also ensured that the training and sensitization of all the members, including the principal magistrate, has been
made mandatory
for the bodies within the period of 60 days from their appointment. Now, how the Juvenile Justice Board should look like? Its sitting of the board has been explained in the Rule 6 of the Model Rules of the Juvenile Justice Act. The board shall hold its sittings in the premises of an observation home or at a place in proximity to the observation home or at a suitable premises in any child care institution meant for CCL. In no circumstances shall it operate from any court or jail premises. So, Model Rule says the Juvenile Justice Board's office should be near to the observation home or any other institution which is for the child in conflict with the law, but in any instance the JJ board should not run from a jail or a court premises. Second, ensure that no persons unconnected with the case remains present in the room when the case is in progress. Right to the privacy of a child has been given important weightage here. So, board has to ensure that no unknown person is present in the board during the proceedings of any child in conflict with the law. Ensure that only those persons in the presence of whom the child feels comfortable are allowed to remain present during the sitting. The board members also has to ensure that if child is intimidated by the presence of somebody, they have
to ask
that person to vacate the room, because the child has to be made comfortable before the proceedings against him can initiate. Hold it sitting in a child friendly premises which shall not look like a courtroom in any manner. The point here is to remember that the case or inquiry of the child in conflict with the law starts in the Juvenile Justice Board and not in a court. So, the board does not have to look like a court. Here the principal magistrate is in simple clothes, the advocates
are asked not to come in their black coats, and social worker members should also have pleasant demeanor while interacting with children.
So, the whole atmosphere of the board should be a child friendly. The sitting arrangements should be such that it enables the board to interact with the child face to face. The board should try and must try to interact with the child. They must try to ask the questions how he
committed an
offence, who persuaded him to commit an offence, use child-friendly techniques and adopt child-friendly attitudes with regard to the body language, facial expressions, eye contact, intonation and volume of voice while addressing the child. The board members are directed to use pleasant body language, pleasant body manners while interacting with the child. In no way they should intimidate or reduce his worth when appearing before the board. Not sit on a raised platform, and there shall be no barriers such as witness boxes or bars between the board and the child. The board should sit in a comfortable room. There should not be a raised dais. The board and the child should be at the same level to easily converse or interact with each other. Now, let us see the two important sections of the Juvenile Justice Act which are in connection with the child in conflict with the law. Let us see what section 5 says. Placement of a person who ceased to be a child during process of inquiry. Section 5 says, where an inquiry has been initiated in respect of any child under this act, and during the course of such inquiry the child completes the age of 18 years, then notwithstanding anything contained in this act or in any other law for the time being in force, The inquiry may be continued by the board and orders may be passed by the board in respect of such person as if such person had continued to be a child. So, let us try to understand what this section says. If an inquiry against a child begins under this law and he turns 18 during the inquiry period, the Juvenile Justice Board will keep looking into the case and will take an appropriate decision even though the child has turned into an adult. I will explain this section with an example. A 17-year-old boy was caught by the police for stealing, and when its case was produced before the board, the boy has turned 18. Now, it is the duty of the board will not look at the date when he was arrested. Instead, the board will look at the date when the offence was committed by a child. So, when he committed an offence, that is on the date of the commission of the offence, the child was 17 years. No doubt he was apprehended while he was 18 years. That does not make a change in the status of his case. His case will be continued looked by the board. Now, let us look at the section 6. Placement of persons who committed an offence when person was below the age of 18 years and was apprehended when they have completed the age of 18 years. Any person who has completed 18 years of age and is apprehended for committing an offence when he was below the age of 18 years, then such person shall, subject to the provisions of this section, be treated as a child during the process of inquiry. The person referred to in subsection 1, if not released on bail by the board, shall be placed in a place of safety during the process of inquiry. The person referred to in subsection 1 shall be treated as per the procedure specified under the provision of this act. Now, students, let us try to understand what section 6 says. It says, if a person who is now 18 years or older but was under 18 years when he allegedly committed a crime, he will be treated as a child and will go throughout that legal procedures which are designed for the children. And if that person has not been granted
bail and there is no need to place him in institutional care, and
since he has attained the age of majority, he is now placed at place of safety even during the inquiry period. Now, we will understand when a case is produced before the board, we will try to understand the procedures in relation to the board. Now, let us see what the section 7 says. Section 7, subclause 1. The board shall meet at such times and shall observe such rules in regard to the transaction of business at its meeting as may be prescribed, and shall ensure that all procedures are child friendly and that the venue is not intimidating to the child and does not resemble as regular courts. A child in conflict with the law may be produced before an individual member of the board when the board is not in sitting. Subclause 3 says, a board may not act withstanding the absence of any member of the board, and no order passed by the board shall be invalid by the reason only of the absence of any member during any stage of the proceedings, provided that there shall be at least 2 members present at the final disposal of the case. In the event of any difference of opinion among the members of the board in the interim or final disposal, the opinion of the majority shall prevail. But when there is no such majority, the opinion of the principal magistrate shall prevail. Now, let us understand this section in a simple words. If the board is not in session, a child who is accused of breaking the law can be brought before just one member of the board, and the roster of the members is to be prepared by the principal magistrate. Here, the comfort of the child is to be seen and has to be ensured that in no circumstances the child is apprehended inside the jail. So, The child, when apprehended within 24 hours, have to be produced before the board. Even if the board is not sitting, it has to be produced before the single member. The board can make a valid decision even if member is absent. However, at the time of final decisions, 2 members should be present, including principal magistrate. So, in the interest of the child, if 2 members are absent, the single member can decide for the child, but when it comes to the final disposal of the case, principal magistrate has to be present mandatorily. If board members disagree on a decision, opinion of the majority will prevail, but if there is no majority, then the opinion of the principal magistrate will prevail. Now, let us see the powers, functions and responsibilities of the board, which are very categorically defined in the Juvenile Justice Act. Now, let us see what section 8 subclause 1 says. Notwithstanding anything contained in any other law for the time being in force, but save as otherwise expressly provided in this Act, the board constituted for any districts shall have the power to deal exclusively with all the proceedings under this Act relating to children in conflict with the law in the area of jurisdiction of such board. The powers conferred on the board by or under this Act may also be exercised by the High Court and the Children's Court when the proceedings come before them under section 19 or in appeal, revision or otherwise. The functions and responsibilities of the board shall include ensuring the informed participation of the child and the parent or guardian in every step of the process, ensuring that the child's rights are protected throughout the process of apprehending the child, inquiry, aftercare and rehabilitation, ensuring availability of legal aid for the child through the legal services institution. Wherever necessary, the board shall provide an interpreter or translator having such qualifications, experience and on payment of such fees as may be prescribed to the child if he fails to understand the language used in the proceedings. Directing the probation officer or in case a probation officer is not available, to the child welfare officer or a social worker to undertake a social investigation into the case and submit social investigation report within a period of 15 days from the date of first production before the board to ascertain the circumstances in which the alleged offence was committed by the child. Adjudicate and dispose of cases of children in conflict with the law in accordance with the process of inquiry specified in section 14. Transferring the committee matters concerning the child alleged to be in conflict with the law, but stated to be in need of care and protection at any stage, thereby recognizing that child in conflict with the law can also be the child in need of care and protection simultaneously, and there is a need for the committee and the both to be involved. Disposing of the matters and passing a final order that includes an individual care plan for the child's rehabilitation, including follow-up by the probation officer or the district child protection unit or a member of the non-governmental organization as may be required. Conducting inquiry for the declaring fit person regarding child in care of conflict with the law. Conducting at least one inspection visit every month of residential facilities for children in conflict with the law and recommend action for improvement in quality of services to the district child protection unit and the state government. Order the police for registration of FIR for offences committed against any child in conflict with the law under this Act or any other law for the time being in force on a complaint made in this regard. Order the police for registration of FIR for offences committed against any child in need of care and protection under this Act or any other law for the time being in force on a written complaint by the Child Welfare Committee. Conducting regular inspection of jails meant for adults to check if any child is lodged in such jails and make immediate measures for transfer of such child to the observation home and any other function be prescribed. So, let us try to understand this section in some simple steps. The Juvenile Justice Board is the only authority to handle the cases of children who have broken the law, regardless of what other law says. The final authority for the children in conflict with the law is the Juvenile Justice Board. Both the High Court and the Children Court can also use the powers given to the Juvenile Justice Board when they are reviewing their cases. The Juvenile Justice Board functions and responsibilities in detail are: first, to make sure that the child and their parent or guardian understand and participate in the legal process. So, right to participation is ensured for the child and for his family. Protecting the child rights throughout the process of apprehension, inquiry, aftercare and rehabilitation. The board has to ensure that when police has apprehended the child, no violation of child rights has taken place, police in no way has harmed the child or the probation officer has intimidated the child. It is the duty of the board to ensure that all the rights of the child are protected right from the apprehension. Providing free legal aid to the child. If the child has no idea about his offence and has no family support to hire a legal counsel for him, it is the duty of the board to appoint a legal counsel for him through the District Legal Services Authority. Providing qualified interpreter or translator to the child if he or she fails to understand the language during the course of proceedings. If a child hails from a different state and ended up in a different state, and while his stay in a state he committed a crime to which language he is not aware of, and in this case it is the duty of the board to provide him an interpreter so that he can know what proceedings are initiated and what is going against him in the Juvenile Justice Board. Directing probation officer, child welfare officer, social worker to undertake social investigation report into the case within 15 days to understand the history of the child and to make a good assessment about the case. It is the duty of the board to ensure that the social investigation report is made within 15 days and is also presented before the board within time. To decide and dispose of cases involving minors who have broken the law according to the set inquiry process. After the inquiry, the board can dispose of the case and also decide upon the case. Passing on the case to the Child Welfare Committee where the child is alleged to be in conflict with the law but he needs care and protection. In some cases, dual child are produced before the board where at one hand the child has committed an offence and other hand during inquiry it comes to know that child has nothing to eat, that is why he stole the food. In these cases, it is the duty of the board to pass that case to the Child Welfare Committee also and declare the child as need of care and protection. Making final decision on the case, that includes a plan for the child's rehabilitation and follow up. During the final decision on the case, it is the duty of the board to ensure that individual care plan of the child is made and is also delivered on. Deciding who is suitable to take care of the child in conflict with the law. So, before disposal of the case, the board has to ensure that who will take the custody, who will take the guarantee for the child. Checking residential facilities for CCLs monthly and suggesting improvements. The board has to ensure one compulsory visit to all the child care institutions in the board, and if there are any suggestions, they would give their recommendations for it. Ordering the police to file a report if an offence has been committed against a child in conflict with the law. If a child is present before the board for allegedly committing an offence and during interaction the child explains that some another offence has been committed to him, it is the duty of the board to ensure that FIR is registered against the person who has committed an offence with the child present in the board. Ordering the police to register FIR if an offence has been committed against a child in need of care and protection. So, in this case, if a child is present before the Child Welfare Committee and the child discloses certain facts which requires that an FIR should be registered in this case. So, the committee writes a letter to the Juvenile Justice Board for assisting the registration of FIR in the matter of the child victim. Regularly inspecting adult jails to ensure no minors are held there and moving any found to appropriate juvenile facilities. So, here an open power is given to the Juvenile Justice Board. It is made mandatory for them to visit the jails, and during any such jail visit, if they happen to see any minor lodged there, they can immediately order for the shifting of that minor from the jail to the observation home. Now, let us see section 10, what it says about the apprehension of a child. Now, let me clear, when a child is taken by the police, it is said that he is apprehended, he is not arrested. So, let us see how the apprehension of a child is done according to the section 10. As soon as a child alleged to be in conflict with the law is apprehended by the police, such a child shall be placed under the charge of the Special Juvenile Police Unit or the designated Child Welfare Police Officer, who shall produce the child before the board without any loss of time, but within a period of 24 hours of apprehending the child, excluding the time necessary for the journey from the place where such child was apprehended, provided that no case a child alleged to be in conflict with the law shall be placed in a police lockup or lodged in jail. So, let us see. When a child is suspected of breaking the law is apprehended by the police, he must be given to the care of the concerned child welfare police officer or in the care of the Special Juvenile Police Unit and must be produced before the Juvenile Justice Board as quickly as it is possible, and in no case it should be later than 24 hours. And all this while it is to be ensured by all the stakeholders that in any circumstances child should not be lodged inside the jail or in the cell or a prison by the police. Section 13, information to parents, guardians or probation officer. To ensure the right of participation and safety of a child, it is a duty cast upon all the stakeholders like police, like the probation officer. If any child is apprehended, his parents are to be immediately informed. Let us see what section 13 says. Where a child alleged to be in conflict with the law is apprehended, the officer designated as Child Welfare Police Officer of the police station or the Special Juvenile Police Unit to which such child is brought shall, as soon as possible after apprehending the child, inform the parent or the guardian of such child if they can be found and direct them to be present at the board before which they could be produced. And second, the probation officer, if no probation officer is available, a child welfare officer for preparation and submission within 2 weeks' time to the board a social investigation report containing information regarding the antecedents and family background of the child and other material circumstances likely to be of assistance to the board for making the inquiry. So, let us see what section 13 says. If any child alleged or apprehended for breaking the law, the Child Welfare Police Officer or the officer from the Special Juvenile Police Unit must quickly notify the child parents if they can be located. If they cannot be located, then tell the probation officer and if one probation officer is not available, to the child welfare officer for the immediate compilation of the social investigation report. This report should be prepared within 2 weeks' time and shared with the Juvenile Justice Board for the better appreciation of the facts. If the child has been released on bail by the board must inform the probation officer or the child welfare police officer so that they should not rearrest the child or harm him in any way. Now let us see a very important provision, section 12, bail to a person who is apparently a child alleged to be in conflict with the law. Section 12 deals with the bail of the children in conflict with the law. Let us see what section 12 says. When any person who is apparently a child and is alleged to have committed a bailable or a non-bailable offence is apprehended or detained by the police or brought before a board, such person shall, notwithstanding anything contained in the Code of Criminal Procedure or in any other law for the time being in force, be released on a bail with or without surety or placed under the supervision of a probation officer or under the care of any fit person, provided that such person shall not be so released if there appears a reasonable grounds for believing that the release is likely to bring that person into association with any known criminals or expose the said person to a moral, physical or a psychological danger, or the person's release would defeat the ends of justice, and the board shall record the reasons for denying the bail and circumstances that led to such decision. Release on bail. If a child is suspected of committing a crime, whether a bailable or a non-bailable offence, and is brought before the Juvenile Justice Board by the police, he should generally be released on a bail, and grant of bail is with surety or without surety, and he could be placed under the watch of a probation officer or the legal cum probation officer or in the care of a responsible adult, that can be his family, his parents or his guardians. However, the bail can be denied on the 3 circumstances: if board has reasonable grounds to believe that there is a possibility that by letting the child go free could lead him to hang out with other criminals, or he can come in association with other criminals, or it can put his life in a danger, or third, it can interfere in the course of justice, then only his release on bail can be denied by the board. Now let us see the section 12 subclass 2. When such a person, having been apprehended, is not released on bail under subsection 1 by the officer in charge of the police station, such officer shall cause the person to be kept only in observation home or place of safety as the case may be, and may produce the board before the board. Now, if the bail is not granted to a person, the child in no circumstances can be lodged in a jail. During the intervening period, the child can only be placed in the observation home till the time he is produced before the board. Now, let us see the section 12 subclause 3. When such a person is not released on bail under subsection 1 by the board, it shall make an order sending him to an observation home or a place of safety as the case may be, for such period during the pendency of the inquiry regarding the person as may be specified in the order. When a child in conflict with the law is unable to fulfill the conditions of a bail order within 7 days of the bail, such child shall be produced before the board for modifications of the conditions of the bail. So, if the Juvenile Justice Board decides not to grant bail, they must place a speaking order for it, and if they have sent the child to an observation home or a place of safety till the decision on the bail is pending. And the next clause, which also keeps the child's interest paramount, is review of a bail condition. If a CCL cannot meet the conditions of the bail within 7 days, the child should be brought back before the board for the modifications of the terms and conditions of the bail. So, summing up, bail, we can say that grant of a bail to child in conflict with law is a rule and its rejection is an exception. Now, let us understand, when a child is apprehended, what kind of inquiry he has to go through while dealing his case in the Juvenile Justice Board. And this is covered under section 14 subclause 1, which states, where a child is alleged to be in conflict with the law is produced before the board, and the board shall hold an inquiry in accordance with the provisions of this act and may pass such order in relation to such child as it deems fit under section 17 and 18 of this act. The inquiry under this section shall be completed within a period of 4 months from the date of first production of the child before the board, unless the period is extended for a maximum period of 2 more months by the board, having regard to the circumstances of the case and after recording the reasons in writing for such a extension. So, whenever a case of a child in conflict with the law is produced before the board shall hold an inquiry in accordance with the provisions of this act only, and it is mandatory for the board to complete an inquiry within the period of 4 months from the date of first production. And if the board is not able to complete the inquiry, maximum 2 more months can be granted by the board, and for the reasons recorded for the delay in writing by the board. A preliminary assessment inquiry in case of heinous offences under section 15 shall also be disposed of by the board within period of 3 months from the date of first production of the child before the board. So, in the case if the board decides that a preliminary assessment test shall be conducted, its decision and the inquiry shall be conducted within the period of 3 months. If during the inquiry by the board under subsection 2 for petty offences remains inconclusive even after the extended period, the proceedings shall stand terminated. Here, it is duty casted on the board in a case of petty offence where the inquiry remains inconclusive even after the extended period, the case shall be considered disposed of, provided that for a serious or heinous offence, in case the board requires further extension of time for completion of inquiry, the same shall can only be granted by the Chief Judicial Magistrate as the case may be, for reasons to be recorded in writing. So, inquiry in the Juvenile Justice Board is time bound, and whenever an exception is created there, the board has to give a written order why the delay has been caused in the inquiry of the child. The board shall take the following steps to ensure fair and speedy inquiry, namely, at the time of initiating the inquiry, the board shall satisfy itself that the child in conflict with the law has not been subjected to any ill treatment by the police or by any other person, including a lawyer or a probation officer, and take corrective steps in case of such ill treatment. So, it is the duty of the board to interact with the child whenever the child appears before the board for his date or otherwise, to know that no child rights are violated by anybody, even through the counsel or the probation officer or anybody concerning with the case. In all cases under the Act, the proceedings shall be conducted in a simple manner as possible, and care shall be taken to ensure that the child against whom the proceedings have been instituted is given child-friendly atmosphere during the proceedings. every child brought before the board shall be given the opportunity of being heard and participate in the inquiry. So, let us see kinds of inquiry and we will sum up the kinds of inquiry. In case of petty or serious offences, the case is disposed by the JJB through summary proceedings, which are explained in another law. In case of serious offences, the JJB conducts the inquiry following the procedures of trials in summon, which is also explained in some other law. In case of heinous offences, a preliminary assessment is conducted by the board, and if heinous offence is committed by a child below 16 years, a trial similar to a serious offence is followed by a JJB. So, we have to remember that if a child is below 16 years and he has committed an heinous offence, he will be presumed as a child defined under this act, and in no case his case will be transferred to the children court. And for children above 16 years, based on a preliminary assessment test, the JJB orders where to conduct a trial. It could be in the JJB, or the JJB can decide to transfer the case to the children court. Now, let us see what kind of orders are passed by the JJB. First order, the Juvenile Justice Board can declare that the child did not commit an offence and can pass an order to that effect. The JJB can then order release of the child if he or she is in the state's custody or confined in an observation home and all his bonds and sureties stand discharged. And what are other orders are defined in section 18. Orders regarding to child found to be in conflict with the law. 18 subclause 1 says, where a board is satisfied on inquiry that a child, irrespective of age, has committed a petty offence or a serious offence, or a child below the age of 16 years has committed a heinous offence, then notwithstanding anything contrary contained in any other law for the time being in force, can pass such orders if it thinks so fit. First, allow the child to go home after advice or admonition by following appropriate inquiry and counselling to such child and to his parents or the guardian. Can simply admonish the child or can advise the child. If the child has shown remorse for his mistake, the JJB can, after counselling, can dispose the matter of the child. Can direct the child to participate in group counselling and similar activities. The importance of the counselling in a child life cannot be overruled. So, the Juvenile Justice Board, while disposing of the matter, can order for the counselling so that the child can live his future life comfortably. C. Order the child to perform community service under the supervision of an organization or institution or a specified person, persons or a group of persons identified by the board. So, if a child is found guilty and in order to correct his behavior, the board can order for the community service by the child under the supervision of some NGO or an officer the board may deem fit. Order the child or parents or the guardian of the child to pay fine, provided that in case the child is working, it may be ensured that the provision of any labour law for the time being in force are not violated. Can order fine. Before deciding on the final order, the board can impose fine on the child or on the guardians of the child, and if the child is working, it is the duty of the board to ensure that no labour laws are violated while the child is working. Direct the child to be released on probation of good conduct and placed under the care of any parent, guardian or fit person, on such parent, guardian executing a bond with or without surety as the board may require. So, if a child has committed an offence and the inquiry of the case is completed, the board can dispose of the matter on the guarantee on the personal guarantee of the child or the guarantee of his guardians or parents, and they can give their guarantee after executing surety bonds or personal bond by the child. Direct the child to be released on probation of good conduct and placed under the care and supervision of any fit facility for ensuring the good behavior and child well-being for a period not exceeding 3 years. If a board is making an order for the release of a child, the board can also place the child under the care of a probation officer who will follow up the case and to ensure that child does not fall victim of any offence again. Direct the child to be sent to a special home for such a period not exceeding 3 years, as it thinks fit for providing reformative services including education, skill development, counselling, behaviour, modification and psychiatric support during the period of stay in the special home. If a child has been found guilty of an offence during the inquiry, the JJB board can order for the placement of a child at the special home for a period not exceeding 3 years and can order simultaneously for the education, skill training, counselling and behavior modification of the child for the while he is staying in a special home. Provided that if the conduct and the behavior of the child has been such that it would not be in the interest of other children housed in a special home, the board may send such child to the place of safety. If board has reasons to believe that if this particular child is sent to a special home, it can disturb or interfere with the children staying there earlier, the board may permanently or for the time period it thinks fit can transfer that child to a place of safety. The board may also in addition pass orders to attend school, to attend vocational training centers, to attend a therapeutic center, prohibit the child from visiting or frequenting or appearing at a specified place. If a child is involved with some gang, this condition can be imposed by the board that the child will not frequent or visit that place or mix with that children again. Undergo de-addiction program. If the board has a reason to believe that the child is on substance abuse, the board can order for a de-addiction program also. And where the board after preliminary assessment under section 15 pass an order that there is a need for trial of the said child as an adult, then the board may order transfer of this case to the children's court having jurisdiction. And if a case of a child aged above 16 years is transferred to the children court, further proceedings of that case will continue only in the children court. But if an appeal has been filed in the children's court against the order of the JJB to try that case as an adult, then the children court will decide the appeal first. Now, let us see what the section 21 of the Juvenile Justice Act says. It says that no child shall be sentenced to death or life imprisonment without the possibility of release. So, no two punishments can ever be awarded by the children court or the Juvenile Justice Board is that child cannot be given death penalty or can be given a life imprisonment. So, a quick recap. A child is apprehended by the police only when he has committed a heinous offence or if the apprehension is in the best interest of the child. And no FIR shall be registered by the police in case of petty offences. For serious offences, the Special Juvenile Police Unit or the Child Welfare Police Officer shall record it in the DD entry and no FIR shall be registered. Only in the case of heinous offences, the police will register an FIR. A child alleged to be in conflict with the law shall not be placed in the police lockup or lodged in jail under any circumstances. So, students, today we have understood the rights of the child in conflict with the law in relation to the roles and responsibilities of the Juvenile Justice Board. So, with this, we'll end our today's class, and let me read our concluding statement. The juvenile justice boards are established in every district for dealing with the cases of children in conflict with the law. And one point we should always remember, that every child in conflict with the law is a child in a need of care and protection, as a child in difficult circumstances, who has fallen out of the safety net of a society and who needs a helping hand. The child in conflict with the law has been robbed out of an opportunity of a safe and a secure childhood, and like our children at home, he also deserves second chance to return to the mainstream. And with this, we conclude our chapter on Juvenile Justice Board and the rights of the child in conflict with the law vis-a-vis responsibilities of the Juvenile Justice Board. Thank you so much.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said, but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed, the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia, which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.